I'm Brittany James, and I help consumers understand, protect, and enforce their financial and credit rights. If there's any error on yours, we will fix it. For more info, click the link in our bio or comment section below to speak to one of our licensed attorneys for help. A debt collector just served you with a lawsuit. Your hands are shaking. You don't know what to do. You're thinking, is this real? Can I ignore it? Will the first go to jail? Stop, breathe, and watch this entire video, because what you do in the next 20 days will either save you thousands of dollars or haunt you for the next decade. I'm going to walk you through the 3 options you actually have, the settlement numbers debt collectors don't want you to know, and the one simple step that 95% of people skip, and it costs them everything. Let's go. Section 1. The scale of this problem. Here's something most people don't realize. Debt collection lawsuits are one of the biggest categories clogging up the U.S. court system. We're not talking about a niche legal issue. We're talking about hundreds of thousands of lawsuits filed every single year by companies like Midland Funding, LVNV Funding, Portfolio Recovery Associates, and Resurgent Capital. Each of those companies files on average around 500,000 lawsuits annually, nationwide, every year. And here's the gut punch statistic. Over 95% of people who get sued by a debt collector don't even respond. They do nothing. They freeze. They hope it goes away. And the court just assumes the debt collector is right. A default judgment gets entered. And just like that, a $5,000 credit card bill silently becomes a legal weapon that can be used to drain your bank account, garnish your paycheck, and put a lien on your home. This is the moment where unsecured debt, the kind with no collateral, no property attached, becomes secured. The debt collector now has their hammer, and they will use it. Section 2. The snowball effect. Why doing nothing is devastating. Think it can't get that bad? Consider this real case. A man had a judgment entered against him in 2004. The original amount, about $4,800. By the time it came back around, the debt collector was seeking over $60,000 because the judgment had been accruing interest at 30% for over 2 decades. Here's what most people don't know about judgments. They are not the same as regular debt. The statute of limitations that people always talk about, the rule that says creditors only have a certain number of years to sue you, that clock resets once a judgment is entered. In many states, a civil judgment is valid for 10 years and can be renewed every 10 years, indefinitely. That means a judgment doesn't expire. It grows, and it follows you. So if you've been served and you're thinking about just waiting it out, please don't. That strategy has a price tag attached to it, and it compounds by the year. If this video is already opening your eyes, do yourself one favor right now. Drop a comment below telling me what state you're in and what type of debt this involves. I read the comments and I'll point you toward the right resources. And if you haven't subscribed yet, hit that button. This channel exists specifically to give you the real information that attorneys charge hundreds of dollars an hour to explain. Now let's talk about what you can actually do. Section 3. Your 3 options when you're served. When a debt lawsuit lands in your hands, you have 3 real paths forward. Option 1. Fight it. This one makes sense under specific conditions, mainly if the debt isn't yours, identity theft, or if a third-party debt buyer is suing you. Here's something the debt collection industry doesn't advertise. When a debt gets sold, the buyer often receives very little documentation. We're talking basic spreadsheets, names, balances, maybe phone numbers. The reason they can get away with so little paperwork, because 95% of defendants never show up to challenge them. But when you do show up, when you file an answer and force them into a courtroom, they suddenly have to prove everything. They have to prove you had the original account. They have to prove you breached it. They have to prove the balance is correct. And they have to prove they legally own the debt, which is harder than it sounds when that debt has been sold multiple times across different collection companies. Many debt buyers struggle to meet that burden of proof. That's a defense. If it's an original creditor, say a major bank suing you directly, the math is different. They have the documents. They have the records. Unless there's fraud or identity theft, fighting probably isn't your best angle. Option 2. Settle it. Debt can absolutely be settled for less than what's owed, but the numbers vary significantly depending on who is suing you. If it's an original creditor like a major bank, you're generally looking at settling for somewhere in the range of 40% to 60% of the balance before a judgment is entered. Once they have a judgment, your leverage drops fast. They can start garnishing wages and they know it. If it's a debt buyer, a company like Midland Funding, the numbers get more favorable for you. These companies purchase debt portfolios for pennies on the dollar. According to an FTC report, some of the largest debt buyers pay as little as 4 cents per dollar for the accounts they purchase. That means on a $10,000 debt, they may have paid $400. They want the full balance, but they'll take significantly less, especially if you can show financial hardship, exempt income, like Social Security or VA disability, or that you don't have attachable assets. Settlements in the 25% to 30% range are not uncommon with third-party debt buyers when negotiated properly. One underrated tool, the stipulated judgment, sometimes called a pocket judgment. This lets you agree to a structured payment plan, say 80% of the balance paid over time, backed by a formal agreement. The creditor agrees not to collect while you're paying, and you get manageable terms without the chaos of garnishment. It's more flexible than people realize. Option 3. Bankruptcy. Nobody wants to say the word, but it's worth understanding clearly. If you have one lawsuit and a generally manageable financial picture, you probably don't need it. Handle that lawsuit through fighting or settling. But if you have one lawsuit and 3 more coming, and medical debt, and payday loans, and your income is being stretched across multiple collectors, that's a different conversation. Chapter 7 Bankruptcy eliminates credit card debt, personal loans, and medical bills for most people, and in most cases, people keep their home, their car, their retirement accounts, and their household property. You have to qualify based on income and household size, but the majority of filers do qualify. The recovery timeline surprises people. Credit scores in the 700s within a year after filing are not rare. Clients buying homes while still in Chapter 13, car loan offers arriving within weeks of discharge. Compare that to spending 10 years slowly fighting lawsuits one by one, with interest compounding on every judgment, while your financial life stays on hold. Bankruptcy for many people is not the end, it's the reset button they needed years earlier. Section 4. The one thing you need to do right now. If you take nothing else from this video, take this. File your answer. That's it. That's step 1. You don't need to have your entire legal strategy figured out. You don't need an attorney yet. You just need to respond to the court before your deadline. 20 days in some states, 30 in others. Your answer doesn't have to be complicated. Go through each numbered claim in the lawsuit and state whether you admit it, deny it, or say you don't have enough information to confirm it. Don't over-explain. Don't include your personal story. Don't put in settlement offers. Just respond to what they've alleged. Filing that answer stops a default judgment from being entered automatically. It buys you time, usually several months, to evaluate your options, and within 30 days of your answer, the plaintiff typically has to produce their documentation. That's when you find out how strong their case actually is. One answer. That's the move that keeps every other option open. Debt collection lawsuits are designed to overwhelm you into doing nothing. The industry counts on it. 95% of people hand over the win without ever stepping into the ring. You don't have to be in that 95%. If you found this video valuable, please share it with someone who's dealing with debt right now, because this information genuinely changes outcomes. Hit subscribe for more videos like this. And if you want to explore your specific situation, consult with a consumer law or bankruptcy attorney. Most offer free consultations and can help you understand which path makes sense for you. The path forward exists. You just have to take the first step. I'm Brittany James, and I help consumers understand, protect, and enforce their financial and credit rights. If there's any error on yours, we will fix it. For more info, click the link in our bio or comment section below to speak to one of our licensed attorneys for help.